Welcome IAS aspirants. Grab your notebooks because today's GS Paper 2 explainer here at Rungta IAS Academy is an absolute goldmine. We're looking at a super critical intersection of governance, the Forest Rights Act, and judicial precedents. If you're targeting those high marks in governance and social justice, you really need to pay attention to this. So let's dive right in.
Right off the bat, think about this classic UPSC interview-style question. Can an older court order just nullify a newer act of parliament? Keep this exact constitutional conflict in your mind as we go through today's case study. How you conceptually approach this really shows your grasp of legislative supremacy in India.
Okay, let's set the stage. Recently, the Lucknow bench of the Allahabad High Court had to step in for the Tharus, that's pronounced Tharus, a tribal community in the Palia Kalan Tehsil, or Pialia Kalan Tehsil, over in Lakhimpur, Elkhampur. What happened was the district-level committee, or the DLC, flat-out rejected their forest rights claims. And their reason? A Supreme Court interim order from the year 2000. But hold on, the Forest Rights Act came into force in 2006. That's years after that interim order.
Now, take a look at the statutory composition of this DLC. As future administrators, you absolutely must know the exact makeup of these bodies. It really enriches your mains answers. It's headed by the district collector and includes the divisional forest officer, the district tribal welfare officer, and 3 district panchayat members. It's a powerful, multidisciplinary body, right? Yet, as we'll see, even these high-powered bodies can completely misinterpret the hierarchy of law.
And here is the exact quote you need to memorize for your mains. The FRA 2006 explicitly states that forest rights are recognized, quote, notwithstanding anything contained in any other law for the time being in force. See what Parliament did there? They intentionally designed this law to protect forest dwellers' rights above any prior orders. So when the DLC just ignored this, they actually committed a punishable offense under the Act.
So this brings us to a fundamental legal doctrine. Seriously, note this down for your GS2 paper. Provisions in a later law override inconsistent earlier court orders. By relying on a 2000 interim order instead of the 2006 Act, the DLC completely bypassed legislative intent. The Allahabad High Court caught this and correctly struck down the DLC's rejection, basically reaffirming this core doctrine.
But here's where it gets really interesting from a governance perspective. Notice Step 3. The FRA actually has a strict mechanism to punish these offenses. Step 1, the Gram Sabha issues a 60 days notice. Step 2, the state-level monitoring committee proceeds against the violator. But what did the High Court do? They completely bypassed the Gram Sabha statutory authority and just asked the DLC to reconsider its own offense. Think about the irony here. A court bypassing established statutory mechanisms to ask a committee to judge its own mistake. This is a brilliant critical analysis point for your essays.
And you know, this isn't just an isolated incident in Uttar Pradesh. It illustrates a massive, systemic disregard for the FRA across multiple states. According to the Act, evictions are strictly disallowed until the entire recognition and verification procedure is totally complete, which means all these premature eviction actions we see, completely illegal.
Just look at this timeline of systemic apathy. Over in the Madras High Court, claims were routinely dismissed just citing administrative convenience, from Asaripalam, Asaripalam, in Theni back in 2014, to Perambalur in 2017, all the way to Tuticorin in 2020. But contrast that judicial apathy with the Uttarakhand High Court. They recently stepped up to protect forest dwellers from coercive eviction until the final adjudication in 2026. A totally different approach, right?
A lot of this friction boils down to a classic central versus state legislation battle. Take grazing rights, for example. The Central FRA actively recognizes grazing rights across all forests, yes, even tiger reserves and national parks. But recently, the Madras High Court upheld a grazing ban based entirely on a colonial-era state law, the Tamil Nadu Forest Act of 1882. They basically ignored the overriding central legislation.
Now go back to your constitutional basics. A central law supersedes a state law. It's that simple. By ignoring the FRA in favor of these old colonial-era state acts, lower authorities are just creating administrative chaos. And that is exactly why this recent Allahabad High Court ruling is such a vital corrective step. It's honestly a breath of fresh air for constitutional propriety.
So, let's wrap this up with a little thought experiment for your personality test. Imagine you're sitting right there before the UPSC interview board. They look at you and ask, as an incoming district collector heading a DLC, how would you handle the administrative pressure and resolve this conflict with the Gram Sabha statutory authority under the FRA? Ponder that scenario tonight. Keep studying hard, keep analyzing these governance deficits deeply, And from all of us here at Rungta IAS Academy, we'll see you in the next explainer.